I believe in the Constitution. I believe that one case, the right case, can change the world. If you believe this too, Freedom Counsel is for you. Pursuing a major case can be overwhelming, but we provide a community of practice so that you have the resources available to support your case. My name is Warner Mendenhall, and we are Freedom Counsel. Join Freedom Counsel today. freedomcounsel.org.
With Broken Truth and Freedom Counsel, I'm John Davidson, and that was Warner Mendenhall, our dear friend who passed today. And we are planning a more, I totally broke down on this one. We're planning a more elaborate online kind of memorial soon, once we're all kind of put together over this. But Warner would say the show must go on and the fight continues. And with that in mind, today we have Ryan Heath, who's an attorney representing a client in California, dealing with an unusual court interpretation of anti-SLAPP law, which we're going to teach you what that's about. And also Freedom Counsel's Jeremy Friedman, another California attorney who is also a good friend. Welcome, gentlemen.
Thank you, John.
Yeah, I think we should talk about Warner for a minute. Warner created Freedom Counsel to educate and inform the public and also elevate these cases that are defending the rights of citizens who have been denied due process and so many other things. I personally met him after my movie came out, and he was so happy and excited to see it, and he was so amicable as an attorney, because sometimes it's hard for me as a civilian to reach you guys, because you have to have a certain decorum, and I like to go out and throw punches. But Warner was definitely kind of a cowboy in that regard, and I think we identified similar traits. And I don't know, what do you guys think? Do you want to weigh in?
Well, Warner was a great man, and he devoted his life and his career to fighting principles that we all hold here near and dear to our hearts. When he held his first conference, the COVID litigation conference, he brought together a lot of health freedom people who were in the fight all on our own and individually, and it felt very lonely. And until he made us realize that we had a lot of support and that together we could make a difference. And that has inspired us all. And this is a very difficult day today, but I think you're right. He wants the show and the movement to go on, and I think it's a wonderful thing that you're able to bring to the camera all the work that Warner has done in the past and all that Freedom Counsel can be going forward in the future.
And Ryan, I think Warner was a sort of an advisor on this case. Is that correct?
He was actually lead counsel on this case in the Supreme Court. So this is a devastating loss for the Gavel Project, which is the 501c that we run. Robert Barnes has also signed on. He's doing pro bono work, so I'm hoping he'll take over that lead counsel role, because I'm not licensed in SCOTUS. I'm working on that, but not there yet. Warner was a dear friend, a mentor to me. I worked alongside him on a case out here in Arizona for a charity. Dr. Lee Vliet was our client, and Truth for Health, and did very well on that one. It just wrapped up. It's heartbreaking to lose him, especially for me. I looked up to him so much. He taught me a lot, and I'm just devastated. So for him and his family, my prayers go out. And
we will. The plan is to get a lot of the attorneys and friends and clients that he's helped to sort of come on for a better, more proper show to send him off. But for now, let's focus on this case and let's talk about it. So Ryan, can you kind of give us the summary of the case and what happened with it in the California courts?
Yeah, so this is a kind of interesting backstory. Just to take a step back, I am not a California attorney. I'm an Arizona attorney. I have been working on this case, though, with attorney Tracy Henderson out of California for several years now. This goes back to the COVID-19 mask mandates, and this was a young girl, a teenager at the time, at Coronado Unified School District, Coronado Island, actually, in San Diego. And what happened is she would go into class. This was in January through March of 2021 or 22, excuse me. And she would sit down in class and she would politely take her mask off and she would refuse to leave. And in response to that, for a period of 6 weeks, her teachers humiliated her. They alienated her from her classmates. They would kick her out of class. They would refuse to provide her learning materials. She was denied taking the opportunity to take tests with her friends. She missed a total of 1/3 of a full academic year, actually, as a result of this protest that just kept going on. She would go into class, take her mask off sometimes, and they would move the class into a different room. She would try to chase them very politely the whole time, again, sitting down. The teachers essentially engaged in child abuse in order to try and force this girl to accept the mask mandate, basically compelling orthodoxy. And so under the theory of Tinker v. Des Moines and under the Barnett case out of West Virginia, we decided to file suit under Section 1983. We were alleging that she was engaged in expressive conduct by the action of removing her mask. She was sending a clear message to everyone around her. And as the time went on, I mean, they knew exactly what she was doing. There was no question in their mind that she was sending a message to them. And they knew that it was a message of defiance and a message of disagreement. And regardless, they continued to punish her and try to silence her dissent. And so we filed suit in the California Superior Court in San Diego, and we were hit with actually 4 anti-SLAPP motions at the outset. And it's kind of shocking because obviously the anti-SLAPP is a way to protect litigants who are being sued for engaging protected activity. And the school actually said that they were engaged in protected free speech by shutting down a dissenting viewpoint. We went to a hearing on that. There were many affidavits from teachers. Obviously, we submitted our own affidavits. The court rejected our allegations and favored the defendant's allegations and their affidavits. So they ruled on weighted evidence for the defendant's favor and found that child abuse, in essence, was free speech for the teachers. So this is shutting down a dissenting viewpoint was basically turned into an opportunity to dismiss the case and grant fees. And that was the outset. We appealed, obviously, went to the California Court of Appeal for the Fourth Circuit. The Court of Appeal, without citing anything as far as what the defendants actually did, and the trial court did the same thing. He didn't ever identify the specific actions of the defendants that were protected. They just said that they were protected as a matter of law. They affirmed. We went to, again, the Superior Court on the fee award, challenged it for lack of jurisdiction because the court never actually engaged in the prerequisite steps required by the statute. The way this is supposed to work is that once you file the anti-SLAPP, the defendants carry the initial burden of proving that a prima facie case that they were engaged in protected activity, but they never met that burden. In fact, no court to date has ever explained what protected activity the defendants were engaged in. So they skipped the first prong of the analysis and should have never shifted the burden to us in the second prong to prove the probability of success. So now we're in SCOTUS, and we're hoping to get a favorable outcome there. There's some procedural stuff going on there in SCOTUS that's kind of tricky. We actually had to file a petition for writ of mandate in the California Supreme Court last month because Tracy Henderson was sanctioned by the California Court of Appeal when we went up to the second appeal for this case. They actually claimed that she was engaged in a frivolous lawsuit. She was a frivolous appeal because she challenged jurisdiction. They sanctioned her $13,000, ordered her to pay that and then take class. I think it was a class. She had to report it to the bar, but she's not listed on the caption of the case in the appellate court, so she's not a party for SCOTUS. So we have to actually get her listed, and the California Court of Appeal is refusing to do that, and so we went to the Supreme Court of California. That's the short of it.
Just to fill in the audience, an anti-SLAPP, lawsuit is a strategic lawsuit against public participation. I believe these laws were created to protect the little guy from the big guy. If you wanted to destroy a litigant suing a big corporation, they can just, swamp you in frivolous lawsuits that drain your resources. And the law was created to protect you and also help you reclaim attorney's fees if the big guy loses. So for for this case to be used like that seems to be the opposite of the intent of the law. Jeremy, what do you think about that?
Well, it is a complicated law. I mean, it's basically to protect against a certain type of lawfare when lawsuits are brought not for the purposes of actually winning anything in a court judgment, but it's brought basically as a baseless lawsuit that arises out of the exercise of First Amendment rights. So if you're somebody who is engaged in your First Amendment rights, and you should be able to engage in those rights and not have to face some big lawsuit that's brought against some high-powered plaintiff that has plenty of money and resources to expend. And it doesn't automatically give the defendant a right out. What it does is it gives the defendant an opportunity to make an initial review, to raise this motion within 60 days of the service of the complaint. And then it's the burden on the defendant to show that the action arises out of the exercise of First Amendment rights. And then the burden shifts back to the plaintiff, not to prove that they would win the case, but that they could come up with enough evidence to get to a jury. That can be very difficult when a plaintiff comes without any and needs discovery in order to establish the case. But it should be an easy win, at least past that summary, that motion, if you have a substantive basis for the lawsuit. Is that, Ryan, what happened here? Did they first sort of establish that it arose out of their exercise of First Amendment rights, and then did they then try to shift the burden onto the plaintiff to show that there was some evidence? And did the court just ignore that evidence? What happened?
That's in essence what happened, yeah. So the defendants argued that by punishing the student and shutting down her dissenting viewpoint, they were engaged in free speech. But the court actually never identified specifically what statements and actions of the defendants were the protected activity that they were sued for. It just assumed in the opinion that what they did was legal as a matter of law, and they had every right to punish a student. What the Tinker factors here, when we get to the second prong, are interesting because we allege that she was perfectly healthy. She was not disrupting a learning environment. And she wasn't violating the rights of other students. So those are the two Tinker factors that you have to establish for protected student activity within the school context. And we allege that. We provided affidavits to that. The court rejected those allegations and our sworn statements outright and just favored the defendant, saying it's legal as a matter of law. You can punish a student whenever she decides to protest. The danger of this suit is that it basically provides an avenue for the government to shut down dissenting viewpoints in any circumstance. And then if you sue because your civil rights were violated, let's say the police kick down your door and you sue them because all they have to do is say, we were enforcing a policy, it was free speech, and tough crap, you lose. And that's basically what happened here.
Has what was the settlement, or what was the penalty financially assessed against the plaintiff?
So we are in the low six figures right now for attorney's fees that the plaintiff has been assessed with. So the fee award was granted, and we've been getting hit with the fees for the appeals as well and for the subsequent litigation. This is the craziest lawsuit. I mean, we all understand as attorneys that viewpoint discrimination is inherently unconstitutional. but the courts in this instance rubber stamped viewpoint discrimination, saying only the government's viewpoint on the topic of mask mandates matters. That's the essence of what happened here. They completely eviscerated the First Amendment in California, and this is the most dangerous precedent, I believe, in the whole country because of that.
And she was doing this in 2022?
Yes. This was a 2022 protest, basically the last 6 weeks of the mask mandates in California before Governor Newsom lifted the mandates. She was sitting there. I mean, the crazy thing about it is it's a circumstantial question when we're talking about what is protected speech through expressive conduct. And here we had a situation where California was one of the last states in the entire country to take the masks off the kids. And so by sitting down in class and politely saying these things are stupid, they don't work, and showing that by taking it off and saying, I'm willing to assume that risk on my own, if these things are meant to protect me, well, then I can make that decision. I'm not a sheep. I'm someone who can actually think on my own. And the school said, no, you can't do that. You have to follow this policy. And if you stand up and do anything against it, we're just going to shut it down. And if you sue to try to enforce your First Amendment rights, you're going to end up paying our attorney's fees. So they turned a shield for citizens through anti-SLAPP into a sword for the state to punish dissenting viewpoints. And it is really a dangerous precedent for that reason.
So essentially, she's going to have to pay hundreds of thousands of dollars in fines to the school for attempting to assert her free speech.
Correct. I mean, the craziest part about this, I mean, this girl, there was a lockdown drill on campus during this protest period. They stuck her in a bathroom by herself. She was the only one put in this bathroom. The door didn't have a lock on it. So when she walked in, she realized that if there was an active shooter, the school's plan for her was to stick her in a bathroom where she would be a fish in a barrel. I'm not kidding. The teachers made fun of her. They would belittle her on the daily, like they would call her names. This was child abuse to try and compel orthodoxy, which is what which Barnett says is the whole point of the First Amendment. The government cannot compel conformity of thought on any topic. You have the right to say no or to disagree, and the courts here just completely rubber stamp the government side of the debate.
What was the theory that her case raised against the school district? What would she have had to prove to prevail in the case?
So she would have had to have proven First Amendment protected activity through expressive conduct. We allege that. The court rejected those allegations, which is completely procedurally wrong. And we actually have sworn statements as well the court rejected to that effect. So you're not supposed to benefit the defendant's evidence at this stage of the proceedings over the plaintiffs, and that's what the court did. So we had to prove that she was neither disruptive to the learning environment, that she was not a danger to other students during her protest, and that the circumstances surrounding her protest were sufficient to clearly show what it was that she was conveying to a reasonable person. That's the standard we had to prove. And we had all the right allegations. We had the evidence that would have shown that as well. And we just never got to the point where we got to present our evidence. So we also had a few other tort claims in there. So we had a Bain Act violation that we had alleged. We had also alleged intentional infliction of emotional distress, among a few other things. But we didn't just sue the school district. We sued 20 plus individuals under 42 section 1983. I mean, the Civil Rights Act, the whole point of this lawsuit was to be a nationwide precedent to show that if this happens again, you can't just go ahead and just punish students individually for expressing themselves and disagreeing with the government in these types of circumstances.
Can you explain the Bain Act briefly?
Yeah, the Tom Bain Act is the Civil Rights Act in California. I believe it's codified in section 52.1. Basically what it says is that if the government punishes you or threatens you in your livelihood, your person, physical threats, things like that, in response to you exercising your civil rights, then there are statutory fees that you can actually recover from, among other things. So that was the idea. It's been a while since I've looked at that statute. That's really not at issue right now before SCOTUS. So really what's at issue is whether or not shutting down a dissenting viewpoint, engaging in viewpoint discrimination is a protected activity for the government.
The Tom Bain Act arose out of sort of the anti-terrorism. It's like that you can't use sort of threat of force or intimidation to get somebody to lose their constitutional rights. That seems to fit well in what you're describing in your case, that she was basically has a constitutional right to have expression in the classroom, and they were making all sorts of threats and intimidation to get her to comply, to give up her constitutional rights. And what you described then is that the Court of Appeals and the trial court level, they basically rejected the idea that she has a protected interest. And I could see that when it's a case involving some sort of complex facts, that you've got to go out and prove that these things were made with the right intent, or that the statements are caused injury to her in some way, that you would have to, as a plaintiff, you do have when you're a plaintiff suing on anything that touches upon a constitutional right to speech or petition, you've got to go and get some of your ducks in row before you bring the lawsuit, because you might face an anti-SLAPP suit. But this is not an action arising out of the school district's speech rights. And to the extent that they can somehow say that the school had a right to engage in these, and it's not only speech, it has to be speech over a matter of public interest. And so they would have to show that this action arose from the school district's exercise of First Amendment rights on a matter of public interest. And I still don't understand what the Court of Appeals could possibly say was the school district's speech rights here. But even if they did, they should have been able to meet that with a declaration that just says, this is what happened to me. Although it doesn't sound like there's a legitimate basis, what did they articulate as the reason why she was unable to meet that? Just that they didn't accept the idea that a student should have a free speech right in this instance?
That's essentially it. I mean, so in the trial court, we obviously put forward all of the evidence that we needed to, with declarations from the student explaining I was neither endangering my classmates, I wasn't disrupting the learning environment. It was the teachers who were disrupting the learning environment in response to my speech. Again, the trial court never identified which specific statements and actions were even protected. He just said punishing a student is protected as long as it's related to COVID mask mandates, basically. And then the Court of Appeal, when we went up, we included a very short summary of what happened to this student. We said she was abused, she was belittled, she refused to wear a mask, very short, sweet statement. It was maybe 2 paragraphs. The court found that we actually waived our right to make a prong 1 argument because we didn't include a sufficiently intricate factual statement at the beginning of our appellate brief. But that's not our burden. The burden is on the defendant, even on a de novo review, which what it is here. When you have an anti-SLAPP go to the Court of Appeal, it's de novo. It was never our job to prove that she was not engaged in protected activity, which is what the court said we had to do. They basically shifted the burden to us. And that's one of the arguments we're raising in SCOTUS, is that this is a due process violation. When a statute lays out explicitly steps that have to be followed by the courts, such as putting the defendant, the initial burden on the defendant, you can't rewrite the law as the court and put the burden on the other party. And that's what happened here, is they said, well, because you didn't explain why the punishing a student wasn't protected activity, you forfeited that, and now the defendants win. They never identified, even in their brief, in their responsive brief, what statements and actions were protected. It's just not in the record. So this case is mind-boggling, and I'm pretty optimistic. I know that the chances of getting SCOTUS review are very low, but this is one of those cases where the courts just screwed up so bad and really harmed core constitutional rights to the extent where precedent is going to be dangerous. I think they're actually going to grant this one.
How long does it take if Supreme Court grants it a right to actually be heard?
This is my first SCOTUS case, so I'm not entirely sure how long that takes. I do know that right now we filed our opening brief for our petition for cert back in, I believe it was February, and we got a letter from the clerk in April saying that because Tracy was not listed in the caption, even though the substance of the second appeal was a judgment against her interests and threatens her property interests, and she therefore is substantively a party to the case, they would not accept our petition for cert as written without some clarification from the lower court showing her name on the caption and listing her on the docket. So we are trying to correct that right now. It's a cluster. I can't go to. I'm very frustrated right now with the clerk of the Supreme Court not accepting the petition as written. But unless the California Supreme Court acts expeditiously, which I don't think they're going to in this case, we are going to have to sticker over Tracy's name and then file a second petition for writ of certiorari with her as a sole petitioner and try to combine them. So that's where we're at now.
Mhm.
We have until June 19th to fix this.
There was a petition for review in the California Supreme Court. Is that what happened? And what happened with that?
Yeah, so we filed a motion in the trial court once we were told by the SCOTUS clerk that we needed to add her name to the caption. We moved to basically fix the clerical error, just very briefly recall the case, fix the clerical error, add her name to the caption. The defendants in the case waited the full 14 days to respond, filed an opposition brief on the last day at the last minute. And then the court, I asked them to basically issue an immediate order. I just filed a request for that. They did the next day. And then we immediately, within a day or two, went to the California Supreme Court with a petition for review, the traditional method. And then we also filed that same day a petition for writ of mandate to try and expedite things. Because if we don't have a petition for writ of mandate and that type of relief available, then the court technically doesn't get jurisdiction, the Supreme Court of California, for a full 30 days after the order issues. And the date that we need to fix this clerical error is by June 19th. So we're running up tight on it. I don't think that the petition for review will be granted by then. The timeline doesn't make sense. I think that's the last day. So I've got to make a decision at the end of this week on what we're going to do with the printer. We're likely going to end up stickering over Tracy's name on the caption, and then just filing a second petition for writ of cert afterward.
And the United States Supreme Court wanted you to make this correction and do it by June 19th. Is it possible to ask them for additional time in light of the other procedural hoops you have to jump through?
I'll send you the emails, Jeremy. I've been begging. So, yeah, we've been trying. There, unfortunately, is no mechanism, a procedural mechanism for them to do that, is what we've been told. So we're very hopeful that we can get an answer back from the California Supreme Court so that we don't have to sticker over this very beautiful brief that we've submitted and have it look a little strange. But, if that's the way God wants it to happen, that's the way it is. And I'm not even sure what to do now because Warner Mendenhall's name is at the very top of that as the attorney of record. So I've got to figure out what to do with that too now. I don't know if there are any other Supreme Court attorneys out there that are listening to this that want to weigh in and help. Please email me, ryan.heath@heathlaw.com. I would really appreciate some guidance from you.
How old is the girl now?
She just graduated from college. So she is in her early 20s. So very brave young girl. This girl, just to give some more context, this protest, 6 weeks outside in the winter time on an island in the Pacific, blowing frigid cold air at her every single day. She had to wear a battery operated jacket to stay warm. She had to sit outside. So her school is a special school for singing, dancing, and acting. It's a performing arts school. It's one of the only few in the area in San Diego. And she's out of district. She was going there specifically for that purpose. She had to watch her friends in class play their wind instruments below their mouths while she was told she couldn't learn or attend because she didn't want to wear a mask. She was told she had to sing a duet by herself. She had to direct herself in a play because she didn't want to wear a mask. The school, I mean, they really tormented her. I actually went, hilarious thing, I went and spoke at the school board meeting. It was like February 17th of that year. And I threatened to sue them. And because I'm an Arizona attorney, I'm not licensed there, I got 6 bar charges in response to that speech. The California State Bar sent me a cease and desist, threatening to have me referred for criminal prosecution if I kept speaking at school board meetings, because I'm not licensed in California. I had already contracted with opposing counsel, or with local counsel, Tracy Henderson, way before that. Like there's no issue with me speaking. There was no case for me to seek pro hoc on. They were trying to shut down my opinion. I actually sent them my own cease and desist letter and told them to shove it up their butt. And I never heard back from them.
Was that in Latin?
Yeah.
Now she's getting a crash course on how the judiciary works. It's not the one that we're hoping for.
This is ridiculous. I mean, it's funny that I hadn't heard of this case until yesterday when you mentioned it to me. But I'm not necessarily surprised. When the judiciary does something like this, which is just so at odds with reality and even case law or anything else, what recourse is there for attorneys who want to do the right thing? I mean, who's judging the judges?
It's a great question. Jeremy, you want to weigh in on judicial immunity?
Well, I do have an opinion about it, but it's less practical in the immediate future. And I mean, I think whatever it is that you need to do, you're doing. You file for review, you ask for further review. You don't stop when the appellate process is over. When you have something important like this, you try to bring it to the U.S. Supreme Court. And the fact that the odds are small that they'll take it simply because they have a huge docket. They have a huge workload and they can only take so many of the cases. And there's an argument over whether they take as many as they could or should. But it's a very small percentage in a civil action. And they don't see themselves in a role of trying to correct bad law below. They look for issues that are of national significance or resolving circuit splits that only they can do. But what you can do is what you're doing. The question about what you have when you have the court system, and for that matter, all of government, whether executive or congressional or judicial, when they are doing the wrong thing and they're not being honest in the issues that are before them. They're not even addressing the underlying facts or claims. They can resolve it simply because they have the power of the pen. They just write it down. It's words. They now can use AI to generate whatever sounding decision they want. Does that mean they hold power over us and that the people have no power? It feels that way, doesn't it? I think in the bigger picture, though, they're actually writing their own, gravestone. Every time a court makes a poor decision, they hope that it just isn't looked at, but it is. And the people, the more we know, the more we find out, the power of the judicial system drops. And same thing when it's the executive power, same thing as when it's Congress. History bends towards truth, and you're caught in the middle of standing for truth in a system that doesn't sound like it's paying attention to you. That might change if you can get that Supreme Court decision granting a cert petition. But either way, you're standing for truth, you're fighting for what's right. And every time you face one of these unreviewable decisions by another court, it doesn't mean that in the court of public opinion and in the course of history, they're actually just lessening their own power. You have to have legitimacy to hold power over people. And when you lose legitimacy, you lose your own authority. That's my view.
Well, I mean, it's preposterous that you abused a child. I mean, in fact, it was an entire nation of abused children, frankly. And they took it to another level. I'm shocked that she was the only one.
Yeah,
that's worrisome.
That was, so she wasn't the only one in general. I had many kids that, so I actually, for the Gavel Project, the way this all started is because there were organizations like Alliance Defending Freedom and other organizations that I was reaching out to in my spare time. I got recruited after law school to go work for a big firm out of California, take over their Arizona office. I have a background in sales, so when this was a workers' comp defense firm, I was building a business for them. I spent a lot of time my first year as a lawyer playing golf and taking people to lunch. And then COVID was, literally, I was the class of 2020. So a few months before that, I was actually in Washington, D.C., and I was sitting next to Justice Samuel Alito, who was my professor for constitutional interpretation. I was one of 16 students chosen to do that at my school. And I went and basically quit my job in October of 21 and decided to start a nonprofit because I didn't see anyone else that was actually solving these problems. I saw a lot of organizations that claim to stand for free speech and claim to care about these issues do absolutely nothing. I mean, I was speaking with organizations like ADF, and they were sitting there on their hands saying, oh, this isn't really our thing. And it was frustrating. So I decided to do that. I emptied my family's life savings so I could fly around California teaching kids how to civilly disobey their school's mask mandates. I went from Coronado Island all the way up to Natomas up in Sacramento, teaching kids. So there were kids in South Orange County that were extraordinarily brave. I mean, literally, I was standing outside of the school at points between parents, police officers, and principals saying, go ahead and put that kid in handcuffs and see what happens, because we're going to sue you too. I went all over the state. There was actually one, or if you go to my my Instagram for the charity, the Gavel Project's Instagram, you'll see a successful protest. A few weeks before the mask mandates were lifted, I was up in Natomas, and I helped an elementary school student and a high school student go back to class without their masks on by handing out cease and desist letters saying, if you don't let us in, we're going to sue you personally. And it worked. It only worked in that one instance, but I mean, I led protests all over the state, and the whole point was, predicated on the Rosa Parks model. We were going to go into class, we were going to politely sit down, we were going to say no, thank you, and then we were going to sue. And so we filed multiple lawsuits. We filed a couple in Orange County, one in San Diego, and one of the lawsuits actually we couldn't afford to keep it going with the charity, so we passed it on to a personal injury attorney up there in Orange County. It's still moving forward, and that one we'll see what happens. That's ABC Unified. I think that's in South LA, not Orange County, but the very northern kind of connecting part. And the other one we couldn't afford. We had to dismiss that one. So we're still fighting this GW case, and I'll go to the grave fighting it if I have to. I mean, we're going to get 2 petitions for cert, so hopefully they'll take one of them. I mean, depending on whether the Supreme Court of California accepts this and actually does something with it before June, let's say 15th, then I have to make a decision. So,
well, I had a friend who was on the other side of this equation, and she got sued for her public speech, and she used anti-SLAPP appropriately and won. And I was very pleased with the anti-SLAPP law because it does provide us some protections from Goliath, right? When we speak publicly. But to bastardize it in this way seems like everything in California these days. I mean, they just passed a law, the Nick Shirley law, right, to ban public reporting on certain types of topics. How does that work? The state is definitely under attack by evil forces, and I appreciate what you're doing to get this through. I do hope it works. I guess we should go into final thoughts. Either one of you?
Well, I'll say something. I agree, John. The anti-SLAPP statute is actually a very important statute, but it has to be applied correctly, and it does protect people who are trying to exercise their constitutional rights and who are facing, big moneyed lawfare people. And the fact that it can be used to shut down a civil rights plaintiff, which is what Ryan's client is, and to use the threat of large fee awards, which are important. The fee awards are important. I have a California Supreme Court case defining how you calculate fees under the anti-SLAPP statute. And it's a necessary way of fighting back against lawfare. But when it's used to actually shut down the civil rights plaintiff who has a meritorious claim, I think in this case it reflects from what I hear now, it reflects the insanity that and the desperation that these school districts had in trying to stand up for its tyranny and without legitimate basis. And so they're pulling out all the stops and they're getting the help of the Court of Appeals. And I hope, Ryan, that you can get relief from the Supreme Court and that it doesn't discourage you from continuing to fight for truth, and that your client and all the lawyers that worked on your case can know that you're standing up for what's right. Sometimes decisions are beyond our control, but fighting the good fight is within our control. And so I commend you for it.
Thank you. I mean, there's a reason that Warner signed on to this case and he was doing it pro bono. And it's because this is such an important case for us to fight and to continue to fight. I'm not licensed in SCOTUS. I'm just unfortunately not capable of doing that right now. So I was really leaning on him, and obviously Robert Barnes has signed on as attorney of record. I'm hoping he takes lead, but we could certainly use help, specifically with the weird procedural instance that we're in. I'll close with agreeing with Jeremy that anti-SLAPP is important, but there's a reason that when we went to the Court of Appeal for the second time, at oral argument, I opened up on the sanctions record. I said to the court, I said, I am not here to please the court. I am here to defend the rule of law. And the judges didn't like that, obviously, but they needed to hear it. And Warner probably would have done the same thing. So it's a blessing to have known him and to have had my life touched by him. And I'm going to try to carry on his legacy and keep fighting for what's right.
We spoke a little bit yesterday, and like I said, you were telling me about this case, and that's why you're on today. I think, as we go forward, we're going to continue to gather up all the fruit from the seeds of cases like this that Warner has planted over the past few years. And I'm gonna stop before I get emotional, but he will echo through history with what he's done in cases like this, in cases like what you work on, Jeremy, and Brooke Jackson's case and others. So thank you both for coming out. I know we're kind of a little emotional today, and we miss our friend, but he's not in pain anymore, and I'm very grateful for that. So thank you both, and we'll be back next week.
I just want to say I'm very
I
grateful.
Oh, sorry. Go ahead.
So I just wanted to thank you, John. I know how important you were to and your show and this thing that you've created here with Warner, how important it was to Warner and to all of us.
What a gift that we have, so many hours of great interviews with him that we can pull back on and, get recharged when we kind of want to give up. He was a great man, and I miss him. Okay. Thank you, guys.
I believe in the Constitution. I believe that one case, the right case, can change the world. If you believe this too, Freedom Counsel is for you. Pursuing a major case can be overwhelming, but we provide a community of practice so that you have the resources available to support your case. My name is Warner Mendenhall, and we are Freedom Counsel.